Good day everyone. I'm here to discuss the categories of intellectual property rights. So let us first define intellectual property. Intellectual property is a category of property that includes intangible creations of the human intellect. And there are two types of intellectual property, the industrial property and the copyright. Industrial property. Industrial property is consist of rights relating to inventions, trademarks, industrial designs, and geographical indications. So, pag sinabing industrial property, ito nga yung mga pag-aari upang maprotektahan ang mga inventions or mga creative works ng isang holder. Industrial property rights are exclusive rights that often registered, allowing the operators to protect its investment in product development, a brand or design. Pag sinabing exclusive right, it gives the holder the right para pigilan ng iba mula sa paggamit ng isang protected inventions. So, next is the copyright. It protects rights related to creations of human mind in the fields of literature, scientific, music, arts, and audiovisual works, or etc. The basic rights of ownership of intellectual property are known as intellectual property rights or IPR, which are primarily derived from legislations concerning patents, designs, copyrights, and trademarks. So, to understand copyright, it is a collection of rights that automatically gives the person who creates an original work of authorship, kasama na sa mga karapatang ito ang karapatang ibahagi sa iba ang kanilang work. Sa makatuwid ay pinapayagan ng copyright ang may-ari na pumili ng iba't ibang paraan na magagamit para maisapubliko ang kanilang mga copyright na gawa. So, according to the World Intellectual Property Organizations, there are 7 categories of intellectual property rights. First is the copyright and related rights. Second, trademarks, trade names, and service marks. Third is the geographical indications. Fourth, industrial design. Fifth, patents. 6 are layout designs of integrated circuits, and the last is undisclosed information. Allow me to give you a simple glimpse about copyrights and related rights. Copyrights and related rights protections is an essential component in fostering human creativity and innovations, giving authors, artists, and creators incentives in the form of recognitions and fair economic rewards, increases their activity and output, and can also enhance the results of their works. Let us first identify trademarks, trade names, and trademark. When we say trademark, it is used by a person to identify their goods and distinguish them from similar goods made or sold by others. Kapag naman service mark, it is used by a person in the sale or advertising of services to identify their service and distinguish them from similar services of others. While the trade name naman is used by any person to identify a sole proprietorship, firm, partnership, corporations, associations, union, or other organizations. Normally, trademarks appear on the product or on its packaging, while a service mark appear on advertising for the services. And trade name is an actual or assumed name of business entity and not a name for a specific product or services. The third one is the geographical indications. Geographical indications is a sign used on products that have a specific geographical origin and possess qualities or reputations that are due to that origin. In order to function as a geographical indications, a sign must identify a product as originating in a given place. In addition, the qualities, characteristics, or reputations of the product should be essentially due to the place of origin. Since the qualities depend on the geographical place of productions, there is a clear link between the product and its original place of production. Geographical indication right enables those who have the right to use the indications to prevent its use by a third party whose product does not conform to the applicable standards. However, a geographical indications right enables those who have the right to use the indications to prevent its use by a third party whose product does not conform to the applicable standards. The fourth one is the industrial design. The owner of a registered industrial design has the right to prevent third parties from making, selling, or importing articles bearing or embodying a design which is a copy of the protective design, when such acts are undertaken from commercial purposes. The fifth one is a patent. A patent is an inclusive right granted for an invention. A patent is the granting of a property right by a sovereign authority to an inventor. Number 6 is the layout designs of integrated circuits. In modern technology, integrated circuits are essential elements for a wide range of electrical products, including articles of everyday use such as watches, television sets, washing machines, and cars, as well as sophisticated computers, smartphones, and other digital devices. Developing innovative layout design of integrated circuits is essential for the productions of even smaller digital devices with more functions, while the creations of a new layout design is usually the result of an enormous investment, both in financial terms and in terms of the time required from highly qualified experts. The copying of such layout design may cost only a fraction of the original investment. In order to prevent unauthorized copying of layout design and to provide incentives for investing in this field, the layout designs of integrated circuit is protected under a sui generis intellectual property system. The last category of intellectual property right is the undisclosed information. It refers to information which is secret and has commercial value because it is a secret. Undisclosed information or trade secret is protected in the TRIPS or TRIPS agreement under the framework or discipline of unfair competitions. So again, the copyright. And in addition to what I have said about copyright laws grants authors, artists, and other creators protections for their literary and artistic works. Example given, books, movies, music, paintings, photographs, and software. And give a copyright holder the exclusive right to control reproductions of adaptations of such works for a certain period or time. The copyright can be enumerated as follows. First is the artistic work. It means a painting, a sculpture, a drawing, an engraving, or a photograph, a work of architecture, and any other work of artistic craftsmanship. Second is the literary work. It includes computer programs, tables, and compilations, including computer database. Third is musical work. It means a work consisting of music and any graphical notation of such work. Fourth is dramatic work. It includes any piece of recitations, choreographic work, or entertainment in show. Fifth is the cinematography films. It means any work of visual recording. And the last one is sound recording. It means a recording of sounds. So let's talk about 6 rights of copyright. And as an individual, it is important to know the 6 rights of copyright to avoid copyright strike. First is the right to copy. If one creates something artistic that is fixed in some medium, only that person who holds the copyright may make a copy of the thing created. So it means, kung sino lang ang taong nag-create ng isang creative works, ay siya lang ang pwedeng mag-produce or magpadami ng copy nito dahil he or she has the right to copy. Next is the right to prepare derivative works. A derivative work is a movie made from a book or video game based on a popular movie. It means a derivative work is something that comes from something else. The third one is the right to distribute copies. In the digital world, distributing copies would be posting material on the internet. So if you have the right to distribute the copies, you can produce and distribute it without being copyrighted. The fourth one is the right to perform works publicly. When a play is performed for an audience, it is publicly performed. If a copyright holders allow a play to be performed by others, he or she is entitled to a royalty fee and control over how the work is performed. Fifth is the right of public performance of sound recording by means of digital audio transmission. The last one is the right to display works publicly. In an educational institute, if an instructor shows a copy of a painting in an art class, it is treated as a fair use. In a distance learning course, if the painting placed on a website that is accessible to everybody in the world, making it a public display and not exclusively an educational display in a classroom. Now, let us discuss the patents. A patent is an inclusive right granted for an invention, a product or process that provides a new way of doing something or that offers a new technical solutions to a problem. So, ang patent nga ang nagpo-provides ng protection sa patent owner for their inventions. Protection is granted for a limited period, generally 20 years. So, there are three types of patents: the utility patents, the design patents, and the plant patents. So, first is the utility patents. Utility patents are those inventions that are normally thought of as machines, such as cell phones or an MP3 players. A utility patent protects the structures, compositions, or functions of an invention. Generally speaking, a utility patent lasts 20 years from the earliest filing date. Utility patents are more expensive and difficult to obtain than a design patent. You should always expect the patent office to initially reject your utility patent applications, and you should expect to respond to at least one rejection before your application is possibly allowed. A utility patent can have either broad or narrow protections depending on how broad the patent's claims are. So the next one is the design patents. The design patents are granted to the design of a functional thing. A design patent is used to protect the ornament and non-functional aesthetic of a product. It does not require any maintenance fee payments after the patent is issued. It is also generally less expensive and faster to obtain than a utility patent. However, a design patent is relatively narrow in scope and will only protect the design shown in the patent and other designs which are substantially similar. So, the last type of patent is a plant patent. A plant patent is granted on a new type of plant that is created by human intervention. It is an intellectual property right that protects a new and unique plant's key characteristic from being copied, sold, or used by others. A plant patent can help an inventor secure high profits during the patent protection period by preventing competitors from using the plant. So that's all for the scope of my report. And thank you for listening. I hope you learned something.
And now, after Vanessa discussed the two first category of intellectual property rights, the copyright and patents, now I'm going to discuss the 7 remaining categories. The third category is trademark. Trademark are signals or symbols, examples, logo, and name registered by a manufacturer or merchant to identify goods and services. Protection is usually guaranteed for 10 years and is renewal as long as the trademark continue to be used. Trademarks can be various types. A trademark may be a brand name, trade dress, service mark, certification mark, or collective mark. Sinasabi nga, ang trademark is a sign or a symbol such as a logo or a name that a manufacturer or a merchant register to distinguish the product or a service. Then, yung protection will generally be guaranteed for 10 years and shall be renewed until the trademarks are used. Then, branch are protected by trademark kasi ang trademark is a name of a product or a service that associated with it. Tapos, it defined as something by which customer recognize a product or a source of a product under a trademark law. Then, meron tayong different types of trademark such as a trademark branch, a branch name, trade dress, service mark, certification mark, collective mark. Then you as a manufacturer, if you want to properly protect your trademark, you should conduct a research to find out if others are using a similar mark to yours. Then if not, you should file a trademark application to get your trademark registered. Integrated circuit. Layout design of integrated circuit is a relatively new area in EP or intellectual property which has appeared with computer technology. The programming instructions on the computer chip are implemented through a circuitry printed on semiconductor layer. Design of circuitry of the chip requires great investment of knowledge, skills, capital, and this need to be protected as EP or intellectual property. Yun nga, we all know that integrated circuit is commonly known as a chip or microchip, or the electronic circuit in which the component has been assembled in order or certain order of the surface of a thin semiconductor materials. Sabi nga, sa modern technology daw nga ay ang integrated circuit ay napaka-essential na element for a wide range of electrical product, including articles of everyday use, yung such as television set, mga kinds of machine, cars, as well as yung mga computer, smartphone, and other digital devices. Tapos, in creation, a new layout design is usually the result of enormous investment or a great investment. Napakahalaga ng great investment ng knowledge, ng skills, also in a financial. Then, in order to prevent unauthorized copying of a layout design and to provide incentives for investing in this field, the layout design of integrated circuit is protected under an intellectual property service or system. Fifth category, breeder right. A plant breeder right is a form of intellectual property right guaranteed to a breeder of a new plant varieties. Breeder of a new plant varieties are guaranteed plant breeder right for protection of their varieties against explosion without their permission. A plant breeder right is guaranteed for 25 years in the case of bens and trees and for 20 years in all other cases. Ito nga, ang plant breeder right, also known as a plant variety right, are a right guaranteed to the breeder of a new variety of plant that give the breeder exclusive control over the propagating materials, yung including the seed, cutting, division, tissues culture, and harvested materials katulad ng cut flowers, fruits, and etc. of a new variety of a number of a year. Tapos, itong right na to, or with this right, the breeder can choose to become the exclusive marketer of the variety or to license the variety to others. In order to qualify nga daw for this, a variety must be new, distinct, uniform, and stable. Sinasabi nga, ang plant breeder or ang plant breeder right ay nagagarant for 25 years, then 20 years naman for other cases. Next category is trade secret. A trade secret which is entire equated with or a subset of confidential information is secret or non-public information concerning the commercial practice of proprietary knowledge of a business, public disclosure of which may something be illegal. Unlike patents, trade sectors are protected as long as the information is kept secret. Sabi nga, trade secret are intellectual property right on confidential information which must be sold or licensed. Tapos, according to some research nga, to qualify as a trade secret, the information must be commercially valuable because it is a secret, be known only to a limited person of the group, and be subject to a reasonable step taken by the rightful holder of the information to keep it secret, including the use of confidentiality agreement from business partner and employees. Seventh category is geographical indication. A geographical indication is a sign used on goods to have a specific geographical origin and possess qualities or a reputation due to the place of origin. Most commonly, a geographical indication consists of the name of the place or of origin of the goods. Ang geographical indication used on a product to identify the specific place from which the product is made. Tapos, nagpo-possess nga daw ang geographical indication product a quality, characteristic, or reputation essential attributable to its geographical origin. Tapos, ang geographical indication nga are protected under the trademark section of Intellectual Property Code as collective mark. Tapos nga, as nasabi, the name of the place of origin of the product is the most common geographical indication. 8. Utility models. This concept originated in U.S. or United States patent law. A utility model is an exclusive right guaranteed for an invention which allow the right holder to prevent other for commercially use the protected invention without his permission for a limited period of time. Patent law in India does not provide any registration of utility model. Ang utility model nga daw is similar to patents. Utility model is an exclusive right given for an invention that allow the right holder to prohibit anyone from commercially use the protected invention without his permission. Ang right na to is para sa invention and inventors kung saan para hindi maalaw ang ibang tao na magamit ang invention sa ibang bagay without the permission of the right holder. Last category of intellectual property right. Industrial design. An industrial design right is an intellectual property right that protects the visual design of an object. It is considered with three-dimensional features such as shape or surface of an article, or two-dimensional features such as pattern, line, or color. Industrial design is applied to a wide variety of a product. According to my research nga, ang industrial design nga daw is mean to ornamental or aesthetic aspect of an article. The owner of the protected design nga daw must be able to prevent the manufacture, sale, or importation of article bearing or embodiing a design which is a copy of protected design. Tapos nagkukonsist nga daw, sabi nga, nagkukonsist nga ang industrial design ng three-dimensional feature such as a shape of a product. Then two-dimensional feature naman such as pattern, line, or color of a product. This is the end of our report. Keep safe, God bless, and thank you.